thrilled today to welcome Professor Justin Murray from the New York Law School. Professor Murray has joined us before. He thinks long and hard about these prosecution issues. This is not his first rodeo writing about them. He's done some important work, and today he's here to talk to us about a work in progress that deals with the myth of individualized prosecutorial discretion. I also want to introduce my colleague, Jia-Chen Yu. Ms. Yu is a policy attorney at the Deason Center and works primarily on our initial appearance project and our project on charging time. In other words, how long prosecutors take to make those decisions. And she's graciously agreed to be our moderator for today. So the plan will be this. I'm going to hand it over to Professor Murray, who will speak for as long as he wants to speak, but he'll stop at some point, I know, Justin, and we'll all have a chance to ask questions. At that point, I would invite you all, and Jia-Chen will remind you, to put your cameras on, because we all know how awful it is to try and have a Q&A with something that's just a typed white name on a black box. So please, at the point when we move to conversation, do turn your cameras on if you're at all available. We'll do Q&A until about 4 o'clock Eastern, 3 o'clock Central. At that point, we'll take a minute to let Justin share with us anything he'd like input on. He'll have a chance to ask the group for additional feedback if maybe we haven't covered things he cares about. And we'll wrap it up and get you out of here at precisely 3:15, 4:15, 2:15, depending on where you are in the nation. So with that, I'm going to hand it off to Justin. Take it away.
Thank you so much, Pam, and also to Jia-Chen for moderating today. I'm so grateful to both of you and to the Deason Center for the chance to discuss my current project with this terrific group. Hi to all of you who are here today. Thank you for being here. The title of my presentation is Prosecutorial Discretion and the Myth of Individualized Enforcement. I'm guessing that the first concept in that title, prosecutorial discretion, is very familiar to most of you already. Pam already alluded to the fact that it's a recurring topic of conversation in this venue. But just very briefly, to set the groundwork for our conversation, when a person commits a crime, or I guess more precisely, when there's probable cause to believe that a person committed a crime, a prosecutor can, of course, choose to file criminal charges, but the prosecutor can also take a variety of other actions, like issuing a warning, sending a letter demanding restitution to the victim, or enrolling the suspect in a diversion program. Or the prosecutor can simply decline to charge and do nothing whatsoever. Beyond that, the prosecutor generally gets to decide whether to file or accept a plea to one charge or many charges, a misdemeanor charge or a felony charge, an offense carrying a mandatory minimum or a different offense that doesn't, a sentence enhancement or no enhancement, and much, much more. This, in a nutshell, is prosecutorial discretion. It's an expansive realm of choice in which prosecutors get to decide whether, when, and how to enforce the criminal law. The discretionary decisions of prosecutors, together with those of the police, play a key role in shaping how criminal law on the books plays out on the ground. Nothing I've said just now is especially new or surprising. Scholars, lawyers, reformers, all of you, and to an increasing degree, voters, are well aware of the power prosecutors hold in our penal system. Prosecutorial discretion is familiar, well-trodden ground. But the second concept in my title, what I call the myth of individualized enforcement, requires a little bit more unpacking. I will start with a quick synopsis of what I mean when I say the myth of individualized enforcement, and I'll talk a little bit about why I think the myth is important and why I think the myth is a myth. After that, I'll expand on a few key points, open the floor for Q&A and discussion. The myth of individualized enforcement consists of a set of claims or assumptions. It's not always an explicit claim, but a presupposition oftentimes, about how prosecutors exercise discretion, or more precisely, how conventional prosecutors, as opposed to progressive or reformist prosecutors, exercise discretion. The first claim or assumption within the myth is that the way conventional prosecutors go about exercising discretion involves looking at the particular facts and equities of each individual case that comes before them and applying their professional judgment to the circumstances of that case to decide what enforcement response is appropriate. The second claim or assumption is the flip side of the first. Because conventional prosecutors supposedly follow a practice of exercising discretion one case at a time, based on facts and equities peculiar to each individual matter, what they don't do is they don't refuse to enforce criminal statutes categorically or across the board. In short, the myth rests on the descriptive claim or assumption that conventional prosecutors' discretionary decision-making is individualized as opposed to categorical. And as is true of many politically salient myths, this myth's descriptive premise is tightly bound together with a normative idea about how prosecutors are supposed to behave and what role their discretion ought to play in a legitimate penal system. Stated briefly, the myth's normative conception goes something like this. A prosecutor who categorically refuses to enforce a criminal statute illegitimately usurps the role of a legislator by acting like a policymaker, whereas a prosecutor who exercises discretion in an individualized manner appropriately acts like an impartial enforcer of the laws. You can find faint traces of the ideas that comprise the myth of individualized enforcement in a lot of older materials, occasional judicial opinions or scholarly articles dating back to the early to mid 20th century, maybe even earlier. I haven't traced it back to its origins. I can't make that claim just yet. But what I can say is that the ideas did not have much legal or political resonance until very recently, really just the past 5 years or so. And I think there are two key developments, recent developments, that fueled the myth's rise. The first, sorry, lost track of where I was. The first and most important factor is the emergence on the national scene of a growing number of elected prosecutors who are more or less aligned with the goals of the criminal justice reform movement. These prosecutors, often called progressive prosecutors, though I prefer the term reformist prosecutors, I won't belabor the point, have won elections in dozens of cities and counties across the country, including some of the nation's biggest population centers, and they now represent, by some estimates, around 20% of the US population. Many of these reformist prosecutors, though importantly not all of them, have openly and explicitly embraced certain kinds of categorical non-prosecution policies or categorical diversion policies. For instance, a policy saying this office will no longer prosecute marijuana possession offenses, or this office will no longer seek the death penalty, or we will no longer pursue 3-strike sentence enhancements, or we will seek diversion or restitution rather than criminal punishment for a first-time shoplifter, or what have you. With some reformist prosecutors openly advertising discretionary policies of these kinds that promise categorical or semi-categorical non-enforcement, their critics perceived an opportunity to paint them as inappropriately political or partisan by leveraging the myth of individualized enforcement. The second factor in the myth's rise is that in the years just before reformist or progressive prosecutors started winning significant numbers of elections, a somewhat comparable debate was playing out in federal administrative law. President Obama's signature deferred action initiatives, DAPA and DACA, were denounced by critics and celebrated by supporters for exercising the executive's discretion over key immigration-related matters through categorical mechanisms rather than ad hoc ones. The issues surrounding DAPA and DACA were not exactly the same as those now confronting reformist prosecutors, but they do bear a strong family resemblance. And so by the time reformist prosecutors were unveiling their non-enforcement measures, the intellectual battle lines were largely drawn. The legal and political blowback confronting reformist prosecutors has been swift and fierce. Predictably, much of the backlash revolves around traditional tough on crime themes. If we prosecute and punish less people, deterrence goes away and society goes to hell in a handbasket. Reformist prosecutors have powerful rejoinders to these arguments, and that side of the controversy is not my main concern here, though it is, of course, important. What interests me here is how central the myth of individualized enforcement has become in the critiques directed against reformist prosecutors. The myth formed the centerpiece of Governor DeSantis's case for removing Tampa's elected prosecutor Andrew Warren from office. Former Governor Rick Scott relied on similar reasons to transfer first-degree murder cases away from Orlando's elected DA Aramis Ayala because of her promise not to seek death sentences. The myth also lies at the heart of the lawsuit that the Los Angeles Prosecutors Union has filed against their own DA, George Gascon, challenging his policy against seeking 3 strikes or other sentence enhancements. This list could be multiplied many times over. I gather that there are similar issues percolating in legislative debates over there in Texas as we speak. The set of ideas that I am calling the myth of individualized enforcement have become powerful rhetorical weapons in current ideological struggles surrounding criminal prosecution. So my central thesis in this paper and in the presentation today is that the ideas that underpin the myth of individualized enforcement are, in fact, myths. And while some myths are harmless, this one, in my view, most definitely is not. In making this argument, one useful starting point involves reflecting on the ambiguity of the language around which the myth of individualized enforcement is built. There's 2 sets of ambiguities that have some importance. One has to do with the distinction between quote unquote individualized non-enforcement, which according to the myth is good, and categorical non-enforcement, which is bad. And there's a variety of synonyms for categorical. You can use blanket, right? A blanket non-enforcement policy or across the board non-enforcement policy. All these terms are doing the same work and suffer from similar ambiguities, which I'll get into in a moment. There's a second ambiguity that also has some importance, which has to do with what we even mean by non-enforcement, right? Does diversion count as non-enforcement? If you go for a civil fine, or if you reduce to a misdemeanor and don't enforce the felony in that situation, is that non-enforcement or is that different enforcement? I'll put that to the side in the interest of time. Focus on the first one. In this context, categorical or blanket or across the board, it can have at least 2 different meanings. And the critics of reformist prosecutors exploit this ambiguity by sliding between the 2 meanings in ways that make their critique seem stronger than, in my view, it truly is. When they are decrying categorical non-enforcement as illegitimate, calling reformist prosecutors rogue prosecutors who are usurping the role of the legislature, etc., they use the term categorical in the strongest possible sense of a prosecutorial policy to never enforce a provision of the penal code under any circumstances with no exceptions. Talking in this way enables critics to paint reformist prosecutors as doing something fundamentally different from conventional prosecutors, something that, in the view of critics, seems more like a legislative function, making law, not enforcing it. But there is an obvious problem with this version of the critique. While it is true that some reformist prosecutor policies decline to enforce penal provisions in every possible instance, that is not how most of the progressive or reformist prosecutors' policies work. Most of them contain exceptions. Most of them outline categories or cases where enforcement of a penal provision is appropriate in some situations, other categories where it's inappropriate. For instance, prosecute the drug possession statute if cocaine is involved, but not marijuana, or prosecute shoplifting if more than $250 was stolen, but not otherwise, and so on. There's a very real sense in which these policies are categorical, as the critics charge. They do carve up the universe of potentially prosecutable cases into identifiable categories where non-enforcement follows and identifiable categories where enforcement is on the table. But they're not categorical in the strong sense of forbidding any and all prosecutions under inapplicable statute. And yet virtually every critic, not every, but almost all of them, of reformist prosecutors who invoke the myth, lump these types of policies together and brand them all as illegitimate categorical non-enforcement measures. When I was initially thinking about this project, I wasn't sure that this point about the ambiguity of the terms was all that important, right? Is, maybe of some interest, but it seems a little bit deep in the weeds. I've come around to thinking that it does have some importance, and it has importance in the following way. I don't really view the point of my project as trying to say this is the right way to define categorical, right? And the critics are sort of misusing the word categorical by, branding Andrew Warren's promises about not enforcing, abortion prohibitions as categorical. I don't think that's what I want to do. I think what I want to do, though, is I want to take the concept of categorical as it's being used by the critics and use it as a mirror to examine the practices of conventional prosecutors and to say, well, if that is it, let's use the same definition of categorical non-enforcement that's being used as an ideological weapon in relation to reformist prosecutors, and let's use it to evaluate whether conventional prosecutors do in fact have a deep-seated commitment to individualized as opposed to categorical non-enforcement. And the argument that I make, which I now have to present in a rather abbreviated form in the interest of time, is that what you find is that conventional prosecutors today and conventional prosecutors going back a century or longer, they oftentimes are making individualized discretionary decisions, but they also in many areas are making categorical discretionary decisions. Now, they oftentimes are not telling us what their categories are, right? So it oftentimes is happening behind closed doors. It's happening in water cooler conversations between supervisors and line prosecutors. And also the categories are different, right? And so if today's categories for reformist prosecutors might be aimed at trying to reduce racial or class disparities or not criminalizing poverty and mental illness and so on, the traditional categories might have had more to do with race class in the opposite direction. They might have had more to do with, are we dealing with a first-time offender or a recidivist, right? Those are also identifiable categories that carve up the universe of potentially prosecutable cases. Are we dealing with people who have waived their right to a trial and have accepted a guilty plea, or are we not? Let's punish the one group more harshly because of their procedural decisions and the other group less harshly for making the prosecutor's decision easier. There is, when we take the broader definition of categorical non-enforcement that is at work in the critiques of reformist prosecutors and use it as a mirror for evaluating conventional prosecutors' practices, we find that there are all kinds of quite pervasive practices that can fairly be classified as categorical enforcement and non-enforcement practices that are deeply embedded in the praxis of conventional prosecution. To be sure, I do not mean to suggest that there is nothing new happening with reformist prosecutors. I do think that reformist prosecutors are doing something at least relatively new and important with their non-enforcement policies. But what I want to suggest is that the myth of individualized enforcement misidentifies the nature of the difference between conventional and reformist prosecutors' non-enforcement practices. Both sets of prosecutors often, not always, use non-enforcement discretion categorically. Other times they take a more individualized approach. The real difference, I suggest, lies not in the scope of the policies, categorical, individualized, but in who benefits from them and who is burdened by them. At various points in our history, the beneficiaries of prosecutorial non-enforcement by conventional prosecutors have included Southern men who committed pervasive crimes of violence against Black people to maintain white supremacy, settlers committing crimes of theft and dispossession against Indigenous people, violence against women, domestic violence, bootleggers during Prohibition, crimes committed by new European immigrants whose assimilation into American whiteness was helped along by a combination of economic support as well as criminal justice leniency. Other groups of people, most notably, but not exclusively Black men, tended to be excluded from and burdened by the non-enforcement policies and practices of conventional prosecutors. Reformist prosecutors today are trying to redistribute enforcement and non-enforcement and their associated benefits and burdens. Less enforcement, for example, for drug crimes that disproportionately lead to the arrest and conviction of poor people and people of color, but more enforcement for, say, police violence, wage theft, gender violence. So the overall story that I hope emerges from this project is not so much that categorical non-enforcement is an uncomplicated good that we should all support, but that it is and long has been one of the central ways that prosecutorial discretion, both conventional and reformist, is deployed, and that we should lay aside the myth of individualized enforcement and demand that prosecutors take responsibility and be held accountable for the choices they make about how they exercise their broad discretionary power. That's all I have, and open the floor for Q&A.
Thank you so much, Justin. So everybody, I have now allow everybody to be able to unmute themselves if necessary to ask questions. We do have a couple of questions that are already coming in the chat. But if you would like to ask a question, I think the easiest way is just to raise your hand, just so that there's not multiple people speaking at the same time. Justin, that was very interesting. And as a line public defender for many years, it definitely makes me think a lot more nuancedly about the decisions that are made on everyday level. And I think that a lot of what you said about all the conversations that are happening, I think transparency is the key. All the conversations that are happening, that you know that the district attorney's office will prosecute this case if your client fits a particular characteristics, is so common, but just not discussed about. So I'm really glad you brought that point forward. I did have a comment here that I thought was really interesting, that said that someone is interested in talking about a little bit more about categories beyond just offense definitions, possibly venturing into arresting officers' conduct or history, which I thought was very interesting, because definitely I have seen cases that have been dropped solely because the prosecutors themselves know that the officer will not be a good witness or not be a credible witness on the stand. So I'm just I think that was a very interesting question to think about it in somebody brought it up, to think about it in that manner versus just a straight like defendant characteristics per se.
I think that's a great suggestion, and especially because part of the thrust of this project is an effort to show how the idea of categorical enforcement or categorical non-enforcement is a more complicated concept than we think it is when it's being bandied about in our current discourse, and suggesting that it actually captures a lot more types of categories than we usually kind of think we're talking about. And so this may be an example of a blind spot in my own understanding of what the relevant categories are. Certainly I am already trying to look beyond offense definitions, right? So I'm very interested in, for example, the comparable debates that we're having about Aramis Ayala and others who say, I mean, certainly they're still prosecuting murder cases, right? It's not about the offense definition, but they're saying I'm not going to pursue a death penalty. That's a type of sentencing option that statutes make available, but that I'm not interested in, right? I think it's counterproductive. Gascon with his policy, I'm not going to, I'm going to prosecute felonies, but I'm not going to tack on 3 strikes enhancements, right? We're having the same types of debates. That's illegitimate because the legislature made provision for those penalties, and so you can't categorically rule them out. You can only rule them out one case at a time, and so on. But certainly there are other interesting, important aspects of categorical thinking and criteria that I should also consider including within the project.
See, Kanitra has a question. Go ahead, Kanitra.
Question, comment, depends on how it comes out. I think I wrote, as I was reading, you wrote about this, I read it as intellectual hypocrisy or categorical hypocrisy with conventional prosecutors going for this individualized enforcement idea. And immediately I'm expected to eventually read about this wholesale like lay belief that prosecutors don't often go after white collar crime as pointedly as they might go after other types of theft, right? So you vaguely mentioned wage theft, but it's a type of categorical crime that happens among certain people. White collar crime, I mean, embezzlement, laundering, wage theft, those types of crimes, as opposed to theft, burglary, and how we use that language to describe them and who's included in one category, frankly, racially, and who's included in another. And I thought I think it would help to actually double down on who's in certain of these categories, who makes up the majority of the people being tried in these categories. If you don't want to make it about, by racial bias, then maybe think about categories where there is a distinct or could be a distinct classification in the types of people being tried under those. I mean, because again, the lay belief is that prosecutors' offices don't often go after white collar crimes, and they're usually tied to, well, it's hard to, win in these types of cases. So you go after the easy wins. And who are the easy wins against? Why might they be easy wins? Is it easier to believe that a person of color committed a crime than it is any other people? So I thought that could be a good way of thinking about categorizing, or a way of making the argument more nuanced about what we mean by selective enforcement, or what you mean by selective enforcement.
Yeah,
I don't know if I'm making this more convoluted than
you're making it entirely clear. No, that's all very helpful, Kenitra. So, it's not written yet, and so you're entirely well-founded in kind of wondering if it's going to be in the paper. But when I get to the heart of the paper, part 2, kind of unveiling the argument for why the myth of individualized enforcement is a myth, I'm going to start by kind of working through some vice, regulatory, morals offenses, which is, I think, where it's not going to surprise very many people to find that even conventional prosecutors have oftentimes thought, I'm not that interested in prosecuting adultery. I'm not that interested in, the prosecutor a few miles away is really interested in cracking down on gambling, but here we're not interested in doing that, right? And there's plenty of that. But then we're going to move into the areas where there maybe are more surprises, right? And so property offenses, theft offenses, and then we'll go from there into offenses against the person, violent offenses. And as you say, I think that there is a lot to unpack when it comes to property offenses, when it comes to white collar fraud, white collar crime. So much of what could fairly be viewed as theft, when it's perpetrated by well-to-do people, when it's perpetrated by corporations, so much of it is not even conceptualized as criminal. So that's part of it, and maybe sometimes that might be not the prosecutor's fault. Maybe sometimes it's going to be the legislature's fault in terms of what's the scope of their definition of theft or not. But I think quite a bit of it is also what prosecutors and enforcement agents view as true crime. If you shoplift $150 worth of goods from a store, everybody recognizes that as theft. If you intentionally fail to pay $150 to a laborer who is owed $150 in wages, profound social harm flows from that, especially when you aggregate it many, many times over. But even if there is a criminal statute on the books, a lot of people are going to say, just let the labor regulators deal with that through their administrative processes or through civil processes. That might be right, but it calls into question, why is that being conceptualized as a civil problem by prosecutors, right? Such that they refer that matter over to their colleagues in a different division or a different department instead of treating it as a criminal matter. So plenty to unpack there. Certainly a part of the larger argument that there is a kind of intellectual hypocrisy at work, to use your term. Hopefully the lesson that emerges, if I'm able to lay out that data in a sufficiently convincing way, is a takeaway. The larger takeaway would be that there has been categorical enforcement and non-enforcement practices all along, but the categories are changing, right? And so instead of having a debate about reformist prosecutors being illegitimate and deviant because they are using categories, we should be having a substantive debate about the quality of the categories and what they are, what goes into them, whether we're being transparent about them, and what can be said in favor of or against them.
All right, I think our next hand was from Pam. Pam, you're on mute.
Okay, yes. Okay, I think now I'm not on mute. Thank you so much, Justin. That was terrific. Thank you. I want to press you to think about and maybe talk about with us the concept of transparency as perhaps an alternate axis on which to think about blanket and individualized or categorical and individualized use of discretion. And I particularly want to call your attention to some of the colloquy that's been going on. You can find audio tape of it, and I think videotape even in some state legislators, where legislators are saying, well, it would be fine if they just didn't announce it, right? Which is such a counterweight to the developing movement on prosecutorial dashboards and prosecutorial transparency. And I'm wondering if you've given some thought to, again, transparency in terms of either in terms of a public transparency about these policies, and relatedly, whether you've given any thought to formality, meaning the difference between a formal written policy and one that is not. And later on, Shem may double back on that, but I wanted to ask if you could think about those and maybe tell us whether you have any thoughts or if that's of interest.
It's absolutely of interest. I've given a lot of thought to it. I think my thinking is a little bit better formed on transparency. Formality is quite hard. I think that categories have to matter, right? If you have a pervasive or near pervasive custom or practice of non-enforcement in a jurisdiction, but it hasn't been formally reduced into a document or put in a memo, I'm inclined to say that you still have a category. We might not call it a policy. Maybe we call it a policy or custom. Track it. Following federal civil rights law in the Monell space. I think we still have a categorical, if not policy, at least a practice. And I think that we should probably group them together and view them as sharing many of the same characteristics. As far as transparency, I think that your point is a very important one, right? So the end of my opening remarks, I said that the thesis here is not that reformist prosecutors are doing nothing differently. It's that the distinction between a categorical and an individualized approach to discretion doesn't capture the most important differences. I think transparency comes an awful lot closer. So although I do think that you have plentiful examples of categorical non-enforcement and enforcement practices by conventional prosecutors, you have some transparency with conventional prosecutors, but not much. I mean, the dominant tradition is that these, whether they're categorical or individualized, discretionary decision-making for conventional prosecutors is happening in the shadows. And I'm hearing the same thing that you're hearing, Pam. Right? I can't tell you how many times I've heard, both from supporters of reformist prosecutors and their adversaries, everything would be fine if they just kept their mouths shut. Mm-hmm. And I don't see what's fine about that at all. Right? Going back decades, there are very powerful reasons to be concerned about political accountability, because there isn't any legal accountability for how prosecutors exercise their discretion. And if we want, if we're going to build a system in which our primary mechanism of accountability and a mechanism for correcting bad patterns of discretionary decision-making is through the electoral process, then voters have to have some understanding of who they're voting for and what they are doing. And the only way to have that is through transparency. And that's an explicit priority, an explicit part of the reformist prosecutors platform. And I think that it's an attractive one. But, I mean, there are counter arguments, right? There are arguments to be made in favor of keeping everything secret, right? When you tell the world this is the areas where we're not going to be bringing enforcement actions, maybe you reduce deterrence. Okay, you can make that argument, but what's so interesting is nobody wants to make that argument, because you want to be in this debate. You want to be the person who's arguing for individualized apolitical decision making, not the person who's arguing for secrecy and for keeping, right, and for lack of accountability. But I think that when you take the veneer off, that is what a lot of the debate reduces to.
So thank you for that. And just so you know, Justin, I dropped into the chat for you, and if anybody else wants it, I'm happy to post it, a link to some back and forth in the Texas legislature, where you will see legislators, in fact, asking for that secrecy, saying this wouldn't be so bad if you just didn't talk about it publicly. And they're kind of explicit about that. I would, and I appreciate your response, I would push back slightly, and I'll defer to Laura. I'm going to stop now, but I would argue that there's a universe in which if it's not a transparent written policy, it is not in fact a policy at all, in the sense that once it is hidden and unenforceable, I think the space in which to argue about it as categorical is kind of meaningless, because it can go away at any minute. In other words, I would encourage you to think about the durability of internal policies that are not made transparent to the public. I think they have a more ephemeral quality. But I'll hand it off to Laura.
You can I just briefly weigh in on that?
Course.
I mean, I'm very open to that, and this and all of these categories are hard, right? You know, sort of, and the relationship between them is hard. One thought, though, is that even when a policy is openly announced, reduced to writing, and transparently articulated, it also is at risk of rollback. Now I do take your point that there is a degree of entrenchment, but I don't know that there's a qualitative difference, right? And so, I mean, a great example of this is when Chesa Boudin in San Francisco lost his recall vote, and Brooke Jenkins was appointed by the mayor as as his replacement. Almost overnight, you're seeing his policies, many of which were reduced to writing, rolled back virtually instantaneously. You know, same thing for when Governor DeSantis removed Andrew Warren from office, appointed his replacement, and all of a sudden, some of the allegedly categorical but arguably not categorical policies that Andrew Warren had, they're gone.
Yeah, but I would argue that that is a function of the structure of electoral politics. And as long as the elected DA is in, I still think there's something qualitatively different about publication of a policy and non-publication. Anyway, I'll stop now.
Could be.
I think Laura just sent me a message that she has to run soon. Shem, I saw you had your hands up earlier.
Oh, I think she's coming.
Oh.
I mean, sorry, I don't mean to jump the queue. It's just I have to go teach in about 5 minutes. So I want to do very, very quickly. Justin, this was great. And look forward to seeing you next week. But anyway, I actually wanted to pick up on something that Pam said about transparency. And, you know, I think most of you do not know, I am from Oregon, which means that you have some very, very interesting things, because we have everyone probably knows, very, very white population, and yet, surprise, surprise, who is imprisoned, BIPOC individuals. However, you know, we have a very progressive prosecutor in Multnomah County named Mike Schmidt, who hasn't been recalled yet. But one of the things that people are very upset about is we had this new decriminalizing drug thing called Measure 110, which, and of course, my guess is why it passed is that because a lot of people who were being arrested and going through addiction are white, right? I mean, not to be too suspicious, but to be very suspicious, right? Like, of course, you know, they're going to be empathetic, and Oregon, like many other states, has tremendous fentanyl problems. But of course, you know, so we stopped arresting people, which is great. We just never got the sort of rehabilitative part. We have like millions and millions of dollars sitting there. So of course, Mike Schmidt is being blamed for that. And yet, talking about transparency, it's interesting how the less I am running on, you know, progressive prosecutors, so let's say the rest of the state, have actually gotten much more progressive but it is hidden. And so
Mm.
this is not necessarily a question, it's just, this would be interesting for you to look into, right? Like, how has Oregon changed? Now, of course, these less progressive prosecutors in the rest of the state are still dealing with primarily white individuals for the drug stuff. And I don't see, and I mean, these are the same prosecutors are still bringing death penalty charges, even though our governors have halted the death penalty. So I'm like, so this is what, and I haven't quite been able to figure this out. I mean, is it just race, right? Is this the category that is the fulcrum for Oregon? And of course, that would not surprise me, given that, of course, let's not forget, we're the state that when it wrote its constitution, kept out Black individuals, specifically Black individuals, right? Would not, and has a horrific and very long history of racism and the KKK. And I don't quite know how I think out in the Pacific Northwest versus California, these things tend to get really thrown up in the air. And so it's not necessarily a question. It's just, this would be really interested, since I'm like, oh, you haven't written the second part yet. Excellent. I would like you personally to look into this, because I think it would be, as opposed to this is what's happening in California, this is what's happening in New York. Let's look at Oregon. Let's look at Washington, which, in some ways play the same old politics of who we arrest and convict and lock up, and yet in some senses don't. All right, I will.
That's so interesting. I definitely want to dig in more to what's happening in Oregon. I want to pull on one thread that you mentioned, which is that, even as DA Mike Schmidt is getting attacked by other prosecutors for being at the vanguard of some of these progressive and liberalizing reforms, that some of the other more conventional prosecutors are actually kind of following in his shadows, albeit in less ambitious ways. I think that we're seeing similar developments elsewhere, right? So there's a very powerful backlash and countercurrent against progressive or reformist prosecutors, but at the same time, there is the cliche Overton window is expanding even for conventional prosecutors. And I think that that's an important and oftentimes overlooked part of the discussion, right? Because you can say, well, there's 2,300, give or take, local elected prosecutors in this country, and only roughly 50 to 80 of them, depending on how you count, are aligned with this reformist movement, and so they're not really making a splash. And well, there's a few responses to that. One of them is, well, they're disproportionately in very heavy population centers, so they punch above their weight. But another one is that their prominence in the national spotlight, or in the state level spotlight, in Oregon's case, is changing the debate, not just in the places where they hold power, but it's changing the debate that happens elsewhere. It's laying the conditions of possibility. It's showing the sky doesn't fall if you're not prosecuting people for marijuana. Oh, you're not prosecuting death sentences, your murder rate didn't go up, right? That's helpful information, and it can blaze the trail for people who don't want to be caught out in front of social change to at least follow along with what's already been done.
I can get you the info, because where the law school is, which is not where I live. So the law school is in Salem, which is much more conservative. I live in Portland, like most other people. And so that used to be extremely conservative, like pro-death penalty. And now I talk to my students who are working there, and I'm like, what? Exactly. You're being, and of course I'm just like, oh, well, maybe it's because the opioid epidemic hit everyone, including, white middle class people. But all right, well, I again.
Also plausible.
I apologize for dining and leaving, but thank you again so much, everyone. This was a great thing. Bye-bye.
Thanks, Laura.
Hi, Shem, do you have a question? Sorry, I'm going back to all the people who raised their hands and I wouldn't get to.
I didn't have a question. Pam really raised all the things that I was going to speak to, namely transparency and whether or not at this point it's a benefit to just keep your mouth shut. Because if I was going to be advising a progressive prosecutor today, I would tell them, do all the things you want to do, but don't say anything about it. Because I think that's what gets you in trouble. And I think a big drive of the the 10 things progressive prosecutors or reform prosecutors, as you name them or label them, is that you be transparent, that you publish written policies, like Pam says, so that the public knows what you're trying to do. But if that's going to bite you in the butt, then don't.
Yeah.
So really, I don't think I'll stop.
I take your point, and I don't. This is not the paper that's going to make the normative case for transparency and say, reformist prosecutors and categorical policymaking and so on is only legitimate if it's transparent. Other people have made that argument, and I'm not really interested in doing that here. If I were advising reformist prosecutors about whether to be transparent or not, I might, it would depend on the political environment I'm working in, right? And if I'm in a really inhospitable environment, I might do what you suggest. If I'm in a political context, both locally, but also statewide, because we see, you can be well supported by your local constituency and yet be removed from office by a governor, right? So you have to consider both levels of politics and sometimes federal too, but if all the stars are aligning, maybe you can actually excite your base, energize your base through transparency. But on a normative level, I think going back to where we started, right? Before we even layer transparency onto the conversation, so much of the debate is being framed in terms of when reformist prosecutors operate categorically or embrace categorical policies, they're acting illegitimately, right? They're doing something that is sort of contrary to the rule of law. And I think it's a powerful response to that. If you can say, there has been categorical discretionary policies or practices all along, but they've been secretive. And when they're secretive, that is a much more profound hit to the rule of law. And so if the real difference isn't categorical versus individualized, but it's, are we going to be transparent about the categories? I think that it really helpfully reframes that part of the normative debate, right? If prosecutors are openly telling you, here's the categories, yes, it can trigger backlash, but another word for backlash is checks and balances, right? There's a profound sense in which if we're going to have categorical policymaking, it's more compatible with the rule of law to bring it out into the open. I wouldn't say it's a necessary condition for it to be legitimate, or that's the strategic advice I would give in every circumstance, but I think it is not to be overlooked as part of the larger normative conversation.
Justin, I'm just thinking when you talk about rule of law, I think sometimes we think of rule of law as the neutral point where we're starting. It's like, this is the law and you follow it, and this is the starting point. It's like on a scale, it's like right in the middle. When in fact, as you said, often there are lots of biases and lots of hidden policies that move the scale already very much towards a very unequitable application of the law. So I find it very hard to think of prosecutors separate from the police because they work together. And this is a way and often, and I hate to say this, but I feel like there's at least the prosecutor movement is possibly, a little more transparent, moving a little faster than police reform in many ways. And this is and the reformist movement is trying to, in some ways, readjust that scale right towards the middle. We're not even going to the left. We're just going towards the middle a little bit in some senses. I just think it just strikes me a lot about where we think about what the starting point of law and justice is, and which direction and how far we're actually moving the scale. But that was just a comment. But I just want to go to Malia for our question, next question.
Thank you, Cha-Ching.
Thank you. I have two, and they're somewhat contradictory points that I want to raise and kind of get your response to. The first is, I think there is also something to the notion that before you change a law, that you might want to have some experimentation with it. The notion that prosecutors, by creating carte blanche policies, particularly on things like drugs, where there's been a lot of public movement in that direction, are essentially experimenting with what a change in law would look like without having to force legislative action. is interesting, right? That goes to the issue of categorical policy. The other piece that came up for me earlier, and perhaps because I'm come out of Philadelphia, is if you fail to have a categorical policy within a DA's office, then your internal buy-in and compliance may be a real issue, right? And that going public with it is part of the way that you achieve that internal compliance. You know, say from someone who's from a jurisdiction where there was internal dissension on some of those policies. And so if you could address kind of both of those things and how they might fit in. I know they're disparate.
Yes. I mean, they're different points. I don't really take them as contradictory, and I think they're both important and well-founded. So I took your first point to be that, well, if I heard you correctly, it's you know, that before you change the law, you might want to have some room for experimentation, right? So if you're contemplating maybe let's decriminalize marijuana, or let's decriminalize medication-assisted treatment of substance abuse disorders or something along those lines, there might be some value in having prosecutors and police run experiments in a few parts of your state before you take decriminalization statewide. I think that's, if I'm interpreting your point right, I think that is happening, right? We have very concrete, powerful examples of that happening. For example, in Vermont, one of these reformist prosecutors, Sarah George, Chittenden County, actually was able to get the local police buy-in as well. So it was the reformist police department chief as well as the prosecutor having a unified front on saying, oh gosh, I don't remember what the drug was, but it was medication-assisted treatment for, but it was a controlled substance, right? Under Oregon law and also under federal law. And the prosecutor and the police chief, they were not only saying we're not going to arrest people or prosecute people for possessing this this medication, you know, this treatment for substance abuse disorder, we are going to encourage black market diversion of the substance. We want there to be more of this substance in our community. Opioid overdose fatalities went down something like 30 to 40% in the jurisdiction within the span of just a few years of this change in enforcement practices being transparently unveiled. And that provided powerful debate for decriminalization at the statewide level within a very short period of time. I can't promise that I'm not sure that the decriminalization measure passed, but that data powerfully informed legislative debate. Second point, you might need a categorical policy at in the prosecutor's office. If you want to have internal compliance, you might need to have a formal policy. I think you know, I think it certainly helps. Getting buy-in from line prosecutors is one of the biggest challenges that reformist prosecutors are facing. Because in many instances, and you know, you're from Philly, so Larry Krasner is, I think, a great example of this. They come in with sometimes with very bold ideas about doing things quite differently from how most of the staff, who might have been there for years, in some cases decades, for many of the supervisors, had been doing things. And so there's a natural resistance. Like, are you criticizing, you know, are you saying that we were bad people, that we were producing injustice instead of justice? We're not the heroes we thought we were. There's a lot of like prickliness and defensiveness, and thus there's a need for monitoring, because there's not a full alignment of views between, you know, the principal, the elected DA, and the agents who are carrying out their bidding. And so, much like in other areas, you can use clear formal rules, categories, as a way of regulating the discretion of agents to make sure that they're faithful to the principle.
Thank you.
And while you are talking about that, there was a comment that came in from Michelle. It says that if there is a written public policy, the public and the defense bar can push to have it enforced for their clients. As a former prosecutor, I remember policies that weren't written, for which enforcement depended on who was staffing the complaint room that day. And I think that just really that's just another point to enforce what you just talked about in terms of compliance among the line defenders and line prosecutors.
I didn't see that comment. I would love, whoever that was from, I would love to get more information if they want to reach out after the workshop. Very interesting point.
We are almost hitting our 3 o'clock, and it's supposed to go into 3:15. So I just want to take the last 15 minutes to see, Justin, if you have any thoughts or specific points that you want feedback on that we have not addressed, or something that came up during the discussion that you want to discuss a bit more.
I actually think that we've amply covered most of the things that have been on my mind that I've been struggling with. This is a hard project. Some of the concepts are very slippery. The way they're being used in current public discourse is slippery. What are we really debating about? It can be hard to identify. We purport to be arguing about categorical non-enforcement, but are we actually arguing about something else? What is categorical non-enforcement? I think that we've had a chance to dig into a lot of the things that have been troubling me, challenging me about the project. I think one question that I might have for the group, if anyone has thoughts about it, I am very much still in the process of trying to assemble the evidence to support my thesis and also to come up with counter arguments, counter examples, right? The core thesis of conventional prosecutors always have and still are using categorical non-enforcement as an integral part, not the only part, but as an integral part of the way that they approach the exercise of discretion. So I've got plenty of examples of this, but always looking for more. And so if anybody has, particularly salient examples of current prosecutors from the past that jump to mind, oh, so-and-so had a policy of this type, or a lot of prosecutors had a policy of this type, maybe that's categorical. I'd be really interested in hearing what kinds of data people might have awareness of that might have slipped my attention.
I know there are several people who are prosecutors, a current prosecutor, former prosecutors, not to call you out, but I was wondering if y'all might have some insights into things that Justin might be able to look at.
I am a former prosecutor, but I work for a reform prosecutor. So my experience is not one in which I worked for a conventional prosecutor that had policies that, were categorically chose not to prosecute certain offenses. So I don't know if I can offer you much help, but I will certainly keep that in mind for your future research.
Thanks, Jim.
I wonder, does it help to mention jurisdictions where at least in the past, where there was a local prosecutor about prosecuting everything? Like Dallas had a former prosecutor, Wade, who claimed that his policy was to prosecute everything. Everything that came in the door was a chargeable offense. Everyone was charged. And if that practice, in practice, actually was, we prosecute everything that comes through our door. And if it wasn't, what wasn't included? So
it always ends up being
exactly. You've got a public.
It's a fiction. I can
we know.
pretty confidently say it's a fiction without even looking at this. I mean, this paper is about the myth of individualized enforcement. It's not the only kind of mythology, that we've had at various points about prosecutors. And so another one that has a close kinship with the myth of individualized enforcement is the myth of full enforcement. And so sometimes prosecutors say, discretion, what do you mean? I don't have discretion. I just enforce the law. I look at the evidence, and if I have probable cause, I follow the evidence wherever it leads. And I saw a rather startling example of this recently. There was an op-ed in the run-up to Chesa Boudin's recall And it was written by somebody who should have known better, the Manhattan prosecutor who secured a conviction of Harvey Weinstein. Right? This is somebody who really knows her stuff. And I wish I had the line in front of you, but she starts this op-ed by saying, the way I was taught and the way we all were taught in the Manhattan DA's office was law plus evidence equals charge. It's the myth of full enforcement. There's not even individualized enforcement. Forget about it, right? We got probable cause, we're charging the case. Of course, like within 1 or 2 paragraphs after that, she's backpedaling to a version of the myth of individualized enforcement. Of course, we had discretion, we could cut plea agreements, we could do some diversion, we could do a variety of things. Well, yeah, okay, then you should have said that instead of what you said at the beginning, right? But yes, I'm very suspicious, just like I'm suspicious of individualized enforcement types of claims. I'm even more suspicious of the claim that we just follow the evidence wherever we lead. We never look at mitigation. We just charge everything. I mean, certainly when prosecutors say that, they likely are engaged in a crackdown, right? You're probably going to see more robust, more aggressive enforcement, but you're not going to see anything approximating full enforcement. And you always want to kind of keep an eye out for where the now under the radar and, sort of not, the opposite of transparent, right? There's public denial of discretion, but there's pockets of discretion and you have to go out and look for them. And it's probably going to be found in, we'll charge every case initially and then we'll give people huge plea breaks. Or maybe the prosecutor will charge the cases very aggressively, but then the judge will give huge breaks to people who plead guilty, right? Maybe discretion moves out of the prosecutor to the judge. There's a lot of different ways that this can happen, but there's no jurisdiction I'm aware of where you pull discretion out of the system. You can deny its existence, but you can't eliminate it.
I think it also goes to which level the discretion goes, right? For reformists, the policy is very clear. It's supposed to be for the whole office. It comes from the elected official himself. But if the office is not transparent, is it just that one prosecutor that will not charge something? Is it the supervisor that has control over the misdemeanor division that says don't charge criminal trespasses for homeless folks? Or like you are one level up to like felony and misdemeanors or like mental health? I think that goes the breakdown can go quite far, and it's hard to delineate. It can be hard to delineate what constitutes what level categories are you looking at, like what level in the structure of the office?
Yeah, it's a great question. I mean, I'm potentially interested in any of them, but you're certainly right to point out that when you don't have clear policy coming from the top, it doesn't mean that you're not going to have policy in the office. It means that there's a de facto delegation of the policy setting authority or of the authority to figure out what the relevant categories are, downward in the hierarchy of the organization. Some prosecutor offices don't have much of a hierarchy. It's 1 or 2, 3 people. Those offices certainly exist in less populous areas. I mean, but in large urban areas, you're dealing with prosecutors' offices that have, close to 100, sometimes several hundred people in them. And they have complex bureaucratic organizations. And policy is unavoidable in that kind of an environment. And even in the smaller offices, because there are so many cases coming into the prosecutor's office from police departments, even there's important policy choices to be made. It's just that you don't necessarily need a memo to circulate it to your staff. You can circulate it through other means, i.e. word of mouth at the water cooler, through training, and so on.
Thank you so much, Justin. I feel we're coming up on our time, and I want to respect everybody's time. So I just want to make a quick, first of all, I want to thank you again for this wonderful talk. I hope it's been useful for you. And
Thank you.
And also thank you, Kanitra, for reminding me to remind everybody else about our upcoming criminal justice program. Dr. Michelle Stats will be joining us on March 29th at 2 p.m. Central Time. for our Star Justice program, which is related to our small tribal and rural communities. And it's called Place-Based Advocacy and Judging in Rural Areas. And also, after that, on April 4th, Professor Belina Beatty will be joining us both in person and virtual for a book talk. And her book is Manifesting Justice, Wrongly Convicted Women Reclaiming Their Rights. So we're very excited to host her as well. And lastly, our senior policy attorney, Malia Brink, will be presenting our next CJR workshop about the public defense workload, which it will be very exciting on April 20th. So please click the link that check out our link in the chat and you'll be able to register for all of those programs. But thank you so much for joining us today. And if you have any more comments or thoughts, I'm sure Justin will love to hear them via email or phone. And I just thank you everybody for all the great ideas that were here today.
This was really fun and helpful also. Thanks, everybody. Appreciate it.
Great. Have a wonderful afternoon, everybody.